I have clients that come to me that are in this process and they don't know how they got there.
In the court process?
Well, in what I would call a litigation process, where
Okay.
you've got, family claims and notice of claims and judges being involved. How does that end up happening when two parties may not have known that it didn't have to happen?
Yeah, so that really comes down to the lawyer. So some lawyers their practice is to start a court action right away. And because 95% of cases don't go to a full trial, you usually are going to settle somewhere along the way. So that lawyer's, philosophical underpinnings is let's just start the court process, put some pressure on the situation, and if we need a judge to come in and make a decision, they're available. But in the meantime, we'll try and settle something on the side. So the other comment I want to make is that, all our TV shows and every social media and what we're used to seeing in the public is court related, like The Good Wife or Suits. It's all about people being in court. So that's what people are most exposed to and probably have some at least visual understanding of what that process means. There's no TV show about collaborative divorce or what mediation looks like in reality. So I think sometimes clients actually come to a lawyer and think they need to start a court process or they don't fully understand the range of options. Mm-hmm. And so that's where my job and why I think it's great that the lawyers that connect have training and going to court, collaborative mediation or just negotiation. We also help people on the side, sort of like a ghostwriting type situation, so we can present the full range of options to clients and explain each one of them. And I don't have a default, like you have to go to collaborative or you have to go to mediation or you have to start a court action. I really talk to the clients and I encourage them to not start a court action. But sometimes, like I said, if I've got had a file where a father wasn't able to see his child at all, and we write to the mom and say, look, we need to deal with this, and she will not. We don't, in my view, there's not really much of an option there. We have to start a court action. But I do think if the clients that you're talking about, they see a lawyer that has that view that will start a court action and kind of let the chips fall where they may throughout the process, they kind of get into it, not really realizing what the options are or maybe fully appreciating the stress and inefficiency sometimes of a court process and just the difficulty of being involved in litigation.
So can you give us a sense of the cost for a court process?
Yeah, I can. I guess I'll start with most of my collaborative files cost somewhere between 10 and 20,000 and more towards sort of the 10 to 12 range.
Is that for one party? Okay.
Yeah. If they're really efficient and agree on a lot and there's really no issues, which is rare, it could be less than 10. And when there's more issues or more pieces involved, sometimes it's closer to the 20. But I would say that's like the anomaly to be closer to the 20, be more in the 10 to 15 range. The litigation is going to cost usually $30,000 to hundreds of thousands of dollars. It depends on how many applications or what's happening in the court proceeding. To give you an example, like one interim application for spousal support and child support, which is not a final decision, it's just an interim measure until the trial is had, can be $25,000.
Wow, interesting.
Mm-hmm.
Okay, so we have a sense of cost. That's really helpful.